Alliance's Crypto Roundup. Today is Friday, August 4th. My name is Ron Quaranta, chair of the Wall Street Blockchain Alliance. My co-host, David Brill, who is not able to join us because he's traveling. I suspect he's on the Falcon private jet today, Adam, as we speak. And our other co-host, the one and only Josh Klayman, should be joining us shortly. But our guest today, the one and only WSBA member, Adam Goldberg of S&P. Adam, welcome. Thanks for joining.
Thanks so much, Ron. Pleasure to be here.
Great to have you. Before we start again, as we live stream on LinkedIn Live, thank you all for joining us. If you do have questions, please do submit them in the chat. Adam and I and other co-hosts will try to address them as we can. Lots to cover today. Before we start, again, keep in mind, like all of our sessions, nothing discussed today is considered accounting, investment, legal, or tax advice. Adam, you probably hear from me 15 times a week. But let's say hello to the audience. Let the people know what you do, what your role is in your firm.
Sure. My name's Adam Goldberg, and I'm the regulatory subject matter expert for our Network and Regulatory Solutions division at S&P Global Market Intelligence. And in that role, one of my jobs is to cover emerging regulations and emerging products such as digital assets and blockchain. So I'm one of the firm's in-house subject matter experts when it comes to digital assets and blockchain and crypto. And that's one of the reasons I've done a lot of work with Ron and Josh, kind of talking through all the different issues in the industry.
Adam, welcome the one and only Josh Klayman,
Yeah.
who also chairs our legal working group. Josh, thanks for joining us. I hate to throw this at you right away. We've got a lot to cover on the agenda and a fairly hard stop, unfortunately, today at 12:30. But Josh, you and I were talking by email, discussing by email some of the talking points. Is it Rakoff or Judge Rakoff?
As far as I've heard, it's Rakoff. But I defer to the litigators out there
Yeah, I think you had it right. I think it's Rakoff.
Let's dive right into that. Josh, let's start with you. Why are we concerned, or what do we think about Judge Rakoff's opinion, and why is it important? You want to kick us off? And maybe it's worth level setting for some of the folks. And certainly we're talking about the opinion, SEC versus Terraform Labs. But do you want to kick us off on that conversation?
Sure. So there are many things that are important about this opinion. I think there's also some things that are important going both ways, right? There's important distinctions to be made, and there's important points to pull out. So I think just stepping back for a moment, I know in a prior session or in multiple prior sessions, we've talked about Judge Torres's decision in the Ripple case. And we also emphasized, as others did in the space, this is the decision of a single district court judge, and that other jurisdictions aren't bound to follow the reasoning. And even judges in the same court, in the same district, aren't obligated to follow the same reasoning. And so what we saw here with Judge Rakoff in SEC v. Terraform Labs and Do Kwon was that Judge Rakoff expressly declined to follow some of the reasoning from the Ripple case. And I just want to emphasize a few points on this before getting into exactly what or a summary of what Judge Rakoff said on this point. But it is important to remember that there's a difference of procedural posture in these cases. So in the case of SEC v. Ripple, that Judge Torres, was deciding about dual motions for summary judgment, right? So it was much later in the case than where we saw Judge Rakoff weigh in with a motion to dismiss, right? At that stage, the court takes, the facts as alleged by the SEC in the light most favorable to the SEC, right? The assumption is, okay, if we assume that these facts are correct, have they stated a claim? Whereas one could say that with Judge Torres in the Ripple case, that in the judge's view, it appears that the SEC had not proven those facts sufficiently or substantiated those facts enough that there could be a genuine issue of material fact. And so that's important. Also, facts matter, right? There are a lot of facts in the Terraform case that differ from what was alleged in Ripple. And that's important to remember. But getting right to it, what the judge declined to adopt was this reasoning, as we saw in Ripple, where the purchasers who purchased pursuant to programmatic sales, where primary sales to those purchasers were not deemed to be sales of investment contracts, right? And that was differentiated from the sales to professional investors, where it was bilateral, where there was a contract, et cetera. And what what Judge Rakoff said was that he declined to adopt that reasoning, and that in his view, Howey does not make that distinction between purchasers, right? So he was not going to make that distinction here.
Josh,
So
to that point, real quickly for the audience, when we say that, we're saying that Judge Rakoff's notice that Howey doesn't distinguish between the type of purchaser, meaning institution or retail. It doesn't matter who's purchasing it in his interpretation of Howey, correct?
that's right. And I think as I was reading it, I mean, when we think about what Judge Torres said in Ripple, it wasn't that Judge Torres said, "Oh, no retail purchaser could ever."
Right.
It was more for these blind bid-ask programmatic sales, right? Sold over exchange, that those were treated differently, and that when you look at the manner of sale and what the expectations of the purchasers were, of whether those might differ. For example, in the Ripple case, my recollection is that there were some statements saying, these purchasers on exchange or via an exchange, they might not even be aware of the promotions that
Yeah,
Ripple.
that was the justification for her reasoning in Ripple, was that some of these purchasers on exchange might not even know that they were benefiting Ripple Labs when they were purchasing XRP, or benefiting specifically the founders of Ripple Labs, who would be the ones that would be guilty of the securities violations. So because she didn't believe that you can make that connection, because the retail customers might not know of the linkage, she believed that was not a sale of security. I think one thing to note in Judge Rakoff's decision is he declined to follow that. And one of the reasons, for any securities lawyers on the call might know, that Judge Rakoff is the chief judge of the Southern District of New York, and he's also responsible for a large portion of our current understanding of securities law in the United States. Most of the SEC's cases go through the Southern District of New York, and because he's been on the bench so long, and because he's the most senior judge, and because this is one of his specialties, is doing securities type cases, even though his ruling in the Do Kwon case has exactly the same basically persuasive impact as the Judge Torres, where it doesn't even govern the whole district, it doesn't govern the circuit, and no one else in any other district has to follow it. One difference maybe is that he has a large amount of persuasive value. So if you're another judge looking for authoritative law on securities cases, if you're preparing a brief, you've likely quoted Judge Rakoff or one of his previous decisions into how he is interpreted and how the SEC's powers are given. And because he has this robust past of putting out authoritative law that's been upheld by the Second Circuit, and some of it's been upheld and ratified by the Supreme Court, it does give persuasive value to many other judges. So, for example, if a judge in another case in another district, they may be more comfortable citing Judge Rakoff because they may think he's on more solid ground than Judge Torres, who hasn't been on the bench that long and hasn't had this robust career of ruling on these securities cases and dealing with these type of issues.
Adam, thanks.
Yeah.
Go ahead, Josh.
I just to build on what Adam said, another thing, just in addition to Judge Rakoff having a long securities background, my understanding is that in Charlie Shrem's case, about almost 10 years ago, involving Bitcoin, that Rakoff may have been the judge. I believe I saw Charlie tweeting about that. So certainly there's a long history with digital assets as well.
In the context of all of this, both of you know I'm not an attorney, so when I see these opinions, I have to skim read them first to start to digest what's being discussed. But one of the takeaways, and tell me if I'm wrong, and I ask you both for this. I think one of the takeaways in Rakoff's opinion that mirrors some of the stuff I had seen in Judge Torres's opinion was this idea that the token in and of itself is not a security. And Josh, you and I have colleagues in our legal working group where this is one of the pillars of their work and understanding in the crypto space. Is that a correct interpretation? And what is the impact of that commentary or that perspective on potential future cases?
Do you want to take that, Josh, or do you want me to go first?
You can start, Adam.
I think the important thing to understand is when you're not dealing with a securities offering where, let's say, you're directly offering with the SEC, where you register, you put out a securities offering, they review your filing, and then it goes public. When you're dealing with these more novel issues, especially around digital assets that basically the SEC claims this is a security, the person putting it forward claims it's not a security, you default to this test, this Howey test, which Josh mentions, which has certain elements by which you determine if something qualifies as an investment contract. And for that reason, it's hard to say that the underlying token itself, without anything else associated with it, would be an investment contract if you're just looking at the token. I mean, the token we're talking about typically on a blockchain is a technological instrument that's a unit of value on another technological instrument. For it to have the elements of the Howey test, which was seen in both Judge Torres's ruling and in Judge Rakoff's ruling, you have to see kind of, are you basically doing something that you're basically investing in the profits of others to make a return for you? There's nothing intrinsic about a digital token that would embody the elements of Howey to make it an investment contract. Again, if you're not going through a formal registration process to list the security on the front end. So that's one of the reasons I think the judges and most people in the industry are very careful to say the token itself is not a security without some other factors, or if it's not offered to investors, if you don't have people promoting the token to say you should buy this and basically that will benefit other people, or I think you should buy this because I think it will go up in value. Why would it go up in value? Because there are efforts from others that may increase that value, and those hit on the elements of Howey. So I think you do have to be very careful with the distinction. Is not saying the token itself, because the token is just a technological instrument on a blockchain.
Adam, thanks. Josh, weigh in here. And you know, it's always hard doing these shows when the headlines come fast and furious. And I thought I had seen this morning, and please, everyone in the audience, forgive me if I'm misquoting, that Coinbase had asked the court to dismiss the case, I believe, based on some of what we're talking about. Josh, weigh in, and what are your perspectives on that?
So, yes, Coinbase did file a motion to dismiss today. I haven't been all the way through it yet. As one might expect, they touched also.
It's so hard to keep up.
Yeah, I mean, it really is. And honestly, just for a second, just stepping back, you know, it's really interesting. I think the whole industry is really getting a bunch of lessons about procedural postures and what these various stages are, because I don't know that it's often this. There had been so many settlements early on in the digital asset space that now we're really seeing, okay, motion to dismiss, motion for summary judgment, things that people who are not litigators may not be as familiar with. So yeah, Coinbase did point to the major questions doctrine again, as you might expect, because they raised that in their answer and in some other items. And they have, again, I have to go through it, but yeah, I mean, they had several attachments to the exhibits to the complaint, and they discussed the Howey test and, you know, holdings from everything from library on. And I think, yeah, it'll be something I'll be for sure digging into later today.
Yeah,
I know you had a chance to read through it all the way.
I just want to add one thing about the procedural posture, which me and Josh understand as fellow lawyers, is at the stage, let's say, of a motion to dismiss. The standard by which you judge a motion to dismiss is if you grant all the facts as being true. So basically, everything the SEC alleged, the judge will say, if everything they have alleged is true, does it constitute a violation of law? And to dismiss the case, the judge would have to say, I have read everything the SEC has put forward, and I don't think if I granted them everything they say is true in their complaint without contesting any of the evidence. At that point, you basically don't contest anything. Basically, you say, I am granting that everything you said is true. It still doesn't make a case. So it's a very high bar to get it dismissed on a motion to dismiss, because for that reason, because you're basically giving the government the benefit of the doubt that everything they said is true without introducing evidence to basically pick apart some of their legal theories or pick apart some of the evidence that's introduced.
Right. Adam, Josh, thank you both. You know, let's tear up the script a little bit, because Josh, you had mentioned something that I think is really important. And we have this conversation in a lot of meetings, and it's thrown out there a lot, this major questions doctrine. And one of the things that I often see put forward is, well, major questions doctrine, the proponents who say, look, this is why some of the things the SEC is doing aren't great. They should really be elevated to the legislature for commentary new laws, for example. But the other side of that from critics will be, well, it's not systemically important enough impact on the economy that it should be considered a major questions doctrine. Do you agree with that? Adam, let's stay with you, because I know you and I have had a lot of conversations about how the sausage is made in Washington, and I know it's a very complicated series of processes. But is the crypto world really facing a major questions doctrine issue, or is the crypto industry overthinking that?
Well, I think they would like to be facing a major questions doctrine issue. Whether or not they are, one of the problems with this area of law is it's very new and novel. This major questions doctrine is something that this Supreme Court came up essentially with a few years ago and started implementing it, and they've only used it in a couple of cases. And those cases deal with specifically with agency rulemaking and not with enforcement action. There has been a variety of plaintiffs that's tried to take basically the test as the Supreme Court outlined. And one of those elements, as you said, is the pervasive systemic impact on the economy as to whether or not something meets this major question. But one of the problems that some plaintiffs may have is, as of yet, the Supreme Court has not expanded the use of that doctrine to anything outside of agency rulemaking. So the way the authoritative cases, the EPA put forward a regulation of greenhouse gas emissions that they thought fell under the Clean Water Act and the Clean Air Act. And basically what the Supreme Court said is, this is a major question. You can't do this unilaterally without Congress giving you that specific granted power. One of the problems we have here is neither the SEC or CFTC has put forward a rulemaking. So if they went through the formal notice and comment rule process, and then there was a rulemaking, then it might be more ripe for a question challenge. At this point, if you're asking them to invoke the major questions doctrine, it would be an expansion, only in that they have yet to rule on it outside of that specific context of agency rulemaking that's gone through the notice and comment process.
Yeah.
Go ahead, Josh.
I think, and by the way, also, while we've been on here, I did skim through, so I have something to do with it.
I figured you were on your old BlackBerry, Josh.
But yeah, Adam's absolutely right. And I think another thing that the SEC has pointed out in certain of these cases, or in at least one of these cases, is that to its knowledge, I'm paraphrasing here, there haven't really been cases where the major questions doctrine has been invoked that involved questions of an agency enforcing its own statute, enforcing violations of its own statute. So I think that's one point. Also, I mean, the whole Howey line of cases, that's judicially created law, right? And the SEC has resisted defining investment contract in the statute or by, in other ways. And so the question of whether also the major questions doctrine can be extended to judicially created law, I think is a question as well. Now, as to your other question, Ron, about the motion to dismiss, it's really interesting because in one of the sections, and I'm sure it's in others as well, but I just haven't gotten to it. Actually, the Coinbase motion to dismiss references the Terraform decision, and it actually references it in a way that is framed as being positive and in favor of Coinbase's motion to dismiss. It says, and I'll just quote from this, Terraform, for its part, rejected an argument that an investment contract requires a formal common law contract between transacting parties and concluded that no enforceable written contract is required to establish the existence of an investment contract. And then it quotes, wherever the contracting parties agree, that is, scheme that the contractee will make an investment of money in the contractor's profit-seeking endeavor, the court reasoned there's an investment contract. And then it keeps going, and then it says, nowhere in its complaint, this is going back to what Coinbase is saying in its motion to dismiss, nowhere in its complaint does the SEC allege, in the words of the Terraform decision, that the, quote, contracting parties, quote, on Coinbase's exchange, the parties on either side of the blind bid-ask token trades, quote, agreed or, quote, schemed that the buyer's payment would be invested in the seller's profit-seeking endeavor, nor could it. And then it cites Ripple. Yep. And so I think one thing I would just take away from this, just stepping back and obviously still digesting the motion to dismiss, is that all of this because it's happening in real time and it's happening in an overlapping and kind of tapestry-like manner.
Yep.
All of these are building our understanding and interpretation as an industry, right? And as lawyers of these cases, right? And people are trying to distinguish them in real time.
Josh, just to weigh in there real quickly, and for the audience sake, for the laypersons out there like dummy like I am, when you say judicially created law, you're talking case law that substantiates particular points. Yeah.
Exactly.
I want to position a little bit, and I want to ask an opinion. And again, nothing discussed as accounting, legal, investment, or tax advice. Do you think this request, this motion by Coinbase makes it? Will it have legs?
I would say it's gonna be challenging only because of the standard judged as a motion to dismiss. The SEC has been pretty successful at surviving motions to dismiss in most of the cases they've brought against it, basically in their enforcement actions. And again, because it's essentially a low bar.
Right.
You would hope that a government agency taking an enforcement action would not file a case that would be dismissed at a motion to dismiss stage. That would basically say you're getting pretty shoddy lawyering and they shouldn't have brought the case in the first place, because what the judge is telling the agency at that point is you have not actually proved any possible violation of law, even if I grant all your facts. So I would think that's the only reason. That's not to say that the arguments they're bringing forward in this motion to dismiss will not come back at the next stage, which would be the motion for summary judgment, which is where we got to in the Ripple case. Or if it survived a motion to summary judgment, not to say these wouldn't be the exact arguments they would make at trial.
Josh, go. Give me your opinion. And then shout out to Casper for his really lengthy commentary, which we'll address in a moment. Thank you, Casper, for joining. But Josh, what's your opinion?
So I can't give an opinion here on the likelihood, but I do agree with Adam that the bar is low for what needs to be pled in order to survive a motion to dismiss. And so I would say that whatever the outcome here, it's not just because a case goes forward doesn't mean that even if a motion to dismiss is denied, it doesn't mean that the case is going to necessarily go the regulator's way.
Yep. Josh, thank you so much. Adam, to your point earlier, though, it's interesting because you had noted it implies that the SEC brought poor logic or poor structure or work to a particular thing. They work very hard to make sure they are not dismissed. We could make arguments around some of the judicial commentary we've seen in the Voyager bankruptcy, by way of example. The SEC, the judge in that instance was particularly critical. So it's not unprecedented, but it's unlikely.
Yeah, and also just to note, in that case, you're dealing with bankruptcy law, which is a very specific subset of laws which have their own parameters. And that's one of the reasons the judge was very uncomfortable with the arguments the SEC was making, because this is not the proper venue. This is a bankruptcy proceeding. We're trying to see how much assets and liabilities the core entity that went bankrupt has, which creditors have right to those access and what priority. It's not about determining the securities law issues as to what is a security and what is not a security.
Yeah.
But I did want to take a look at what Casper said. One of his basic question was, if we're saying a token itself can't intrinsically be a security and we need more facts and context, if you have an ICO where someone is buying into a public blockchain, how could that be considered a security? I would only say where you read into there is the ICO context itself would be those facts and circumstances that might indicate that you are dealing with a security. Because typically with an ICO, it would be like an IPO. You're essentially purchasing or acquiring an interest in something else. And usually the way the IPO context is you're trying to get a piece of a company because you think the management or the company has a successful product that they're going to go increase the value of that interest that you've acquired. So it may just be around the structure itself as to why that may be, rather than if we're just talking about the intrinsic to actually what a token on a blockchain is.
Adam, thanks. And Casper, no apologies for lengthy comments and questions. That's why you're smarter than I, and we're glad to have you part of what we're doing in the WSBA. Josh, I want to pivot some of this to you because and thank you, Adam, for that answer. I think Casper's relating to something that really sticks out in my mind. Is it possible to determine all circumstances in initial sales? And I would argue the circumstances in initial sales in the crypto digital asset world are very different things than the world you and I know in equities, for example. What's the law's perspective on all circumstances? Or can you render a perspective that might be useful for non-attorneys in that?
I mean, I think when we say facts and circumstances, it means just that, right? You need to look at as many factors as you can, as many facts as you can. That's why the SEC has a cyber unit, or I guess it's now a crypto and cyber unit that crawls through um, online chat rooms and social media and the like, because it all potentially matters and it all potentially could be brought as part of a case. Of course, I think also folks and the law looks at the economic realities. All right. So you may have a fact that says, oh, I called this such and such. I called this not a security. I called this something else. But actually, in fact, if you look at if you don't just look at form and you look at substance, so that matters as well. But I think what's important about facts and circumstances is that from a regulator's perspective, or from the industry's perspective, just because a case is won on some particular facts, right, doesn't mean that that applies to all digital assets. And just to touch upon Casper's comment for a second, I agree with Adam. I mean, the very idea that it's style it as an ICO, I think that is a fact, right? That is a data point when you're looking at this. But also, I think one of the things to look at is, does the token that is granting this access, does it exist? And does the access exist when you sell it? Or are you raising money to later provide someone with access? And that matters, right? And so all of these sorts of things can have an effect. But certainly, it's a better fact if people are not marketing something as an investment,
Right.
as to whether it is in fact an investment. I do think, though, and I believe that probably Casper is aware of this and others, but part of what we're talking about, for those who may be watching and may not be as aware, is the SEC has put forth a theory that in some instances, in settlements and others, it has been that has been what has come forward, which is this, some have called it the embodiment theory, right? That when you have an investment contract, and I'll distinguish this from having a token that could represent an equity interest or some other kind of security, a bond or something like that. But when it's sold as part of an investment contract, the question of whether that token itself actually embodies also the investment contract and is itself a security, as opposed to sort of passing through this investment contract as this piece of software. And that is something where the language in Telegram talking about the tokens are merely alphanumeric code, which Judge Torres and Ripple actually quoted from as well. That is something that represents a different view. Right? And this is one of the most contentious pieces right now, is whether, because the SEC, to my knowledge, is not going to stop bringing cases, at least at present, alleging that the token itself is a security.
Josh, thank you. I just want to be cognizant of time. I want us to move on. We're never going to capture everything we wanted to discuss today. Casper, thanks for the great question. We've got a few more minutes, and we've got a lot of different topics. I want to move to one. Adam, I want to start with you. Stablecoin. Every time I look at a different news source, I see a different article about stablecoin proposed legislation. The most recent one was, and not to be political about it at all, certainly not for me, stablecoin bill coming out of the House, torpedoed by the White House. I feel like that's a lot of hyperbole. Do you have any insights into what specifically happened and what might those next steps be for some of these bills?
Yeah, so I mean, one of the problems is with any of these pieces of legislation, you need to reach a critical mass, essentially, of bipartisan support. First, essentially, because these bills are originating in the House, because there is a potential to maybe have more bipartisan action there. You need to reach a critical mass of bipartisan support in the House to make it out of the House. Then you need it to go to the Senate. You need to have a corresponding critical mass of bipartisan action in the Senate. And then you would need the White House to approve it, because if they veto it, then you would need essentially 2/3 of each chamber to override the veto. So it's a high bar. And also in the Senate, you likely need a 60 vote threshold even to get through a filibuster, just to get the bill on the floor and voted on. Yep. So very high bars. One of the things that happened was the House essentially moved forward with what their GOP proposal was for stablecoin legislation. they did an extensive markup where they did adopt Democratic amendments to try and win Democratic support, which is notable. Many of these bills come up to markup and basically they just shoot down all the amendments from the opposing party. They're like, we're going to go it alone. There was a genuine effort by McHenry and the other members of the committee to really incorporate the Democratic feedback and try to win Democratic votes. But I think because of where the bill started at, it is uncomfortable for the White House. So for the White House coming out publicly against it before it even makes it to the Senate, that does really harm its prospect of eventually becoming law, as I said, because then you don't only have to get 60 votes in the Senate, you then have to get 67 votes to override the veto, which is almost impossible if it's not a national security bill.
Adam, I'm going to let the cat out of the bag for the audience a little bit, and if you're not okay with this, I'll apologize later. But as you and I are going to be working with Dina Ellis, another member of the WSBA, we're launching our policy updates that'll happen on a monthly basis starting later this month, I think. I don't remember the calendar, Adam. So I'm really looking forward to diving deeper into some of these really important kind of policy conversations. We're out of time. I hate when this happens. I'm so sorry about that. Josh, any closing comments from you?
No, except I'm really excited for the policy updates too. So
It'll be a similar format. We'll have questions from the audience. Adam, pleasure having you here. Please come back as a guest. Closing comments or thoughts. What will you be looking at next week?
Really, I think as Josh said, there's so many things happening kind of in the industry and in the different cases. I think for any of the lawyers listening or really anyone trying to follow, it is very hard because we don't have legislation and we don't have regulations. So we're really looking to these individual court cases that are each at their own different procedural steps with their own facts and circumstances. So just kind of seeing what develops, as you said, Coinbase filed today. The SEC will file their motion in response to try and make sure that the case is not dismissed. So really kind of seeing how these outcomes play out will be really interesting.
Adam, as you say, just real quickly, if you would have told me 20 years ago in my career, I'll spend weekends reading court opinions on different things, I would have laughed at you. Now I do it with a lovely Cabernet. We're going to leave it there, everyone. Thank you all for joining. Casper and everyone else who watched, thank you for the questions and comments. See us next week. Have a great weekend, everyone.
Have a great weekend, everyone. Thank you.
Bye-bye.